Afternoon, everyone. We're very happy for you to join us today for this webinar. I am very glad to introduce Julie Schrager, who has been a legal writing coach at SHIP for 12 years and speaks to lawyers and law students about legal writing, including this fall at the University of Chicago, Howard, and Fordham so far. Her other two amazing webinars, which I highly recommend, that she hosted for the Belonging Project. The first one, Finishing Touches, Revising, Editing, and Proofreading Your Own Work. And the second one, Grammar and Punctuation, What You Didn't Learn in School, are both available for on-demand viewing on the Belonging Project website. And I will actually include links to both of those recordings in the post of an email that will go out to all the attendees. I also encourage you to ask as many questions as you'd like while you have Julie here. She has great experience and insights, a lot that I will take in myself. So please welcome Julie.
Thank you so much, Sin, and thank you to Seifarth for sponsoring the Belonging Project. So just a few words about the Belonging Project for those of you who are here for the first time. And if you are, I urge you to go back to the website and watch many of the amazing webinars that have been recorded over the past few months. So the Belonging Project was founded based on the principle of Ubuntu, which was coined by Archbishop Desmond Tutu during apartheid to explain the idea that our individual success and soul really depend on the efforts and soul of the collective. So the Belonging Project was founded during this pandemic to ensure that diverse lawyers and law students are not left behind by the unrest and disadvantages that are affecting all of us this summer. So over the course of the last few months, the Belonging Project has recorded webinars, has lists of resources, provided one-on-one coaching, and will continue to do so for the coming month or two before the project might take another form. So thank you so much. Our format today will be Sin Vargas asking me questions that we've collected before the session, and then I really would love it for you all to offer up questions as we go along. And don't ever feel like you need to wait until the end of what I'm saying or the end of this session. Just toss them out, and no question is too big or small or silly or hard. If it is too hard, I'll tell you I can't answer it, or I'll look it up for you, but please share any thoughts that you have as we go along.
So wonderful. So Julie, our first question is, what type of paragraph structure and paragraph length are most effective?
So I have quantitative rules for a bunch of things that I'll talk about today. So my real preference for paragraph length, and this isn't just mine, but many partners who I've worked with, is that you never want a paragraph to be longer than half a page. So when paragraphs are super long, they're really hard to read, they're really dense. You remember like that Russian literature that you had to read in, high school and college, where like it would be a whole page that was one paragraph. Remember how hard that was to get into? So half a page, that goes for whether you're writing in 12-point or 14-point type. I know it's a little harder with 14-point type, but you're still going to try to do that. Easy way to check that is you just look through your work and make sure your paragraphs are half a page. With respect to structure, every paragraph you write should start with a topic sentence or with some transition from the paragraph before it. So a topic sentence, y'all might have learned this in school at some point, is a sentence saying what the paragraph is about. What I like to do, and makes it easier for me, is to ask myself this question: why should my reader care about what's in this paragraph? And the topic sentence is the answer to that question. Why should my reader care about what's in this paragraph? If you are just connecting one paragraph to the one beforehand, it's always great to use a transition. So words like further, moreover. Instead, if you're saying something on the other side, for example, if you're explaining something that you started to explain in the paragraph before, those are all great ways to start paragraphs. Another quick way to check that, when I'm reading something longer for the first time, I just flip through and look at the first sentences of all of my paragraphs and make sure that they are setting out my points.
Great. The next question, what conventions of legal method and usage will a legally trained reader expect me to know?
So that one is a great one. So there are a few points here. The first thing is that a legally trained reader and lawyers at law firms or judges, if you're doing an externship or a clerkship, or if you're in-house at a legal department, most readers will expect you to know the general format of legal writing that many of you learned in law school, although I know everyone didn't. And that's some version of the CRAC or IRAC formula, but I think CRAC is more effective. So there you are starting your organizational structure of a point is going to start with you setting out your point, which is the answer to the question or the argument that you're making in a brief. Then you set out the rule you used to reach that conclusion or make that argument. Then you explain the rule. That's a lot of what we do as lawyers, is explain how statutes and cases and other forms of law regulations apply to things. And then you apply that rule to the facts of your case. And then perhaps you sum it up at the end. So readers are going to expect you to know that that's the general structure of legal writing. Readers will also expect you to understand the general format of whatever it is that you're writing. So some of that is going to be when you are a younger lawyer at a firm and in-house, one of your big jobs is really understanding the rules. And that means the rules of any court that you're writing for, the rules if your law firm has preferred formats and organizations for things that they do. For example, at our law firm, on the corporate side, there's a pretty straightforward memo format that people use, which would mean you'd write it's single spaced. On the litigation side, we mostly write using double spaced writing. So you're expected to know what something should look like. And that might be rules as in, oh, I need a jurisdictional statement if I'm writing something for a court of appeals, or rules about how to format whatever it is that you're writing.
How do you reconcile use of the pronoun they when from an inclusive perspective, it is recommended that we use it?
Thank you for asking that question. So the first and most important principle is that if you are writing, if you are referring to someone who uses they as their pronoun, of course you use they in your writing to refer to that singular person. Most style guides now also allow you to use they when you are referring to a singular person and you don't know what that person's pronoun is, or you're referring generally to people who identify with who have varied pronouns that they use. So for example, if I'm referring to someone who uses they, of course you use the word they. If you're referring to more than one person, it is an option to use they. So an example here, each voter should cast their vote in the November 3rd election. So that is technically correct. Each voter should cast their vote. One way to avoid using they as a singular pronoun, because there still will be people out there who aren't familiar with its more common use or who don't know what the latest style guides say, there are some options. You can always make the whole sentence plural. So you could restate my sentence to say, voters should cast their votes on election day. Exact same meaning, and you don't have to address this issue of when you use they for a singular person. The other possibility, and it doesn't work in this sentence, but for example, if you said the plaintiff must state their case for negligence, You can fix that one by using the name if you're talking about a specific case. So it could be Mr. Smith, I guess in that case you would know must state his, but you could replace it with the name if it's something that is not gender specific there. And then you can also make it plural. And then you can also take out a pronoun altogether and say the plaintiff must state a case. So those are all options. I predict within the next 5 years, it's going to be very common that people use there to refer to a singular person. It's not that common in the legal world at this point.
Great. One question that I personally would love to know is capitalization in subject line of email. What is the proper way to address this?
So this one, I got to tell you, I did a workshop at a company, at a client of Schiff's a few years ago, and it wasn't even in my substance to talk about the ray line in emails, and it ended up being like 15 minutes of our hour because it turned out to be something that people were totally fascinated by. So first thing, let me take a step back. Everybody knows that that subject line, that ray line, is really one of the most important parts of many emails that we send. Out there in the marketing world, like it means you'll either look at an email or you won't look at an email. For you all, I hope everybody's going to read your emails, even if you have a bad ray line, but you never want to take any chances, right? So my overall rule is that ray lines should be between 5 to 9 words. That's your max. One thing I read online for marketers is it's supposed to be 28 to 39 characters, which is about what I said, is about 5 to 9 words. So you look at that, and then you don't want to make the ray line or really anything else you write look like it's like, you know, yelling at you. You know how when people use like all bold or all underlines or bold and underline and italics, writing feels like it's yelling at you. So you're never going to use all caps. And I would say never capitalize small words that you wouldn't capitalize in headers generally. So that's like conjunctions and or for, prepositions of, to, on, those kinds of words. Articles, and if they're not at the start. So I would thinking about all those principles, I'd take a look at it and see if, you know, if you're saying something that's always capitalized, like you were talking about Veterans Day, for example, you would capitalize Veterans and Day, right? Because it's the name of the holiday. But aside from that, I would consider capitalizing the first word and then using lowercase through the rest of it, unless it looks better to you to use initial caps, which means capital first letters of the words, but not these super small ones. So another thing, and as I said, I could go on about ray lines, so will stop me if I keep on going on for too long. But another thing that you really want to consider when you're writing work emails is if your email chain is starting to take a new turn and you are on a new subject, you may want to start a new email chain with a new ray line, because it gets very complicated for all of us. You know, we get so many emails. If like you're talking about Thanksgiving and the ray line still says Halloween, right? You're not going to remember, you're not going to be able to find it again. So think about that when email chains go on for too long.
Well, I just realized I've been yelling at a lot of people. So.
And if that's your intent, you go ahead with it. Like I do that with my older daughter sometimes when it is like, you know, call me or else, but you don't always have to do that.
Great. Okay, the next question. What information should I include in the facts section of my memo or brief to ensure that I have set out a clear and accurate explanation of the procedural and factual context for my issues?
So this is a great question. And some of it is, I feel like the person who asked it really knows the answer to it because she put it in the question that she asked. So the answer, whenever you are writing a memo or a brief and you have a facts section, you've got to make sure that all of the facts you use in your analysis or in your argument are in that facts section. Okay, judges get super mad at you if they're reading your argument and you refer to some fact and it's not in your facts section, and they're like, whoa, I'm on page 17. Why am I finding out about this here? So that's rule number one. Anything you use in your analysis or your argument has to be in your facts section up front. And then the other point that I want to make is that the additional facts that you need are the ones that this person set out in the question. You need whatever additional facts are necessary to set out the factual and legal context and to tell a story, right? We're not professional storytellers as lawyers, but when we are setting out the facts of an issue that we're addressing, or of our client's claim or our client's defenses or what happened in the accident, we want people to read it, right? And we want people to be interested in it. Otherwise, we wouldn't be writing it. So it's got to tell a story, which means it needs whatever additional facts, in addition to the ones you'll use later, are necessary to tell a story. And then you've got to know, by knowing who's reading your piece of writing, what do they know? What do they need to know that will set out an adequate factual context for what I'm writing?
Okay. Next question. Can you provide an example of when to use a hyphen, when to use an N dash, and when to use an M dash?
Yes, because an M dash is my favorite persuasive punctuation mark. So I like talking about it whenever anybody lets me talk about it. So, okay, these are 3 little dashes, but they're actually of different lengths. So I got to tell you, before, I don't even know, probably before 5 years ago, I had no idea that they were 3 different things, that there was a hyphen, an N dash, and an M dash. And so you know, N dash and M dash are named after how long they are. The idea was an N dash was as long as an N, and an M dash was as long as an M. And that's like in, old type font days. So you use a hyphen, and a hyphen, you guys know this, is on your number keypad between, I'm looking at my number keypad, between the 0 and the plus and equal button. So a hyphen is the shortest among these, and we use hyphens to connect compound adjectives. So if it is a long-held belief, that gets connected by a hyphen. Okay, if it's a widely held belief, that doesn't get connected by anything because it falls within the exception that says compound adjectives are connected by hyphens, but not when the first word is an adverb ending in ly. So hyphens are used to connect compound adjectives. Okay, N dashes, and this one's the most boring, I think, of the 3. We use those when we are connecting numbers. So when you're doing like page numbers, like 17 to 18, that gets connected with an N dash. And you make an N dash by, let me look it up right here, using the control key and the minus key on your numbers keypad. I don't know that one by heart because I never use N dashes, or not very often. So you connect numbers with an N dash, control, minus key. And then an M dash, and this one I would encourage you all to start experimenting with because it really is a great punctuation mark. So you make it by using control and alt and the minus sign on your number keypad. There are like other ways, but that's the way I know how to do it, so I use that. So when you are writing, you can use an M dash for emphasis. So instead of using parentheses around something, a sort of side point in the middle of a sentence, or using commas around it, if you are writing something that you really want to emphasize and you're trying to be punchy, you can use M dashes on both sides of that clause instead of commas or parentheses. So one cautionary note, I wouldn't do it like, more than once in a sentence. I wouldn't do it in every sentence that you write because it's a little maybe too punchy at that point. I would definitely consider it in memos, in briefs, and absolutely in any business development pieces that you're writing. I help a lot with blog posts at Schiff, and we use them all the time, writing in blog posts for like typical people to read what we're saying about cases or new laws or something like that.
I'm learning so much that in addition to yelling at people, I've been connecting my numbers all wrong. Next question, how should I properly cite online sources?
So this one is definitely beyond my expertise, but online sources are covered by the Blue Book rule number 18. And for those of you who aren't super familiar with the Blue Book is out there to teach lawyers how to cite in all legal documents. It's got some rules that apply just for articles, law reviews, that kind of academic stuff. And then it's got some rules that apply to briefs that are filed with courts, and it's got some rules that apply to everything. So the online sources is in Rule 18. There is an updated Blue Book that just came out, a 20th edition this summer, I believe. So I would check that out. The general principle, it's very practical, is that you're citing online sources the way you would cite print sources because the purpose is the same, right? You got to cite in such a way that people can find what you're citing to. So what I do to keep track of that kind of stuff is, I'll have like a Blue Book around and I'll keep, I use those little flags that have different colors and just keep them on the pages that I use a lot. And that's the way to keep track of like, oh man, I got to cite another complicated online source. So, here's Rule 18 and it's highlighted for me.
Wonderful. Now we're going to go to quotation and punctuation marks. What is the rule around quotation marks and other punctuation marks? More specifically, when should other punctuation marks go inside or outside quotation marks?
I always think of the movie Inside Out when I hear this kind of a question, because it's always like, do they go inside or do they go outside? So the rule is that periods and commas always go inside quotation marks, okay? Semicolons and colons always go outside quotation marks. And question marks and exclamation points go inside if they're part of the quote, but go outside if not. So a corollary question I get to this one is, when do you use single quotes and when do you use double quotes? So single quotes, like some people used to use them to be like, oh my, so-called life. I would avoid using that at this point. It's a little too, affected. Didn't it look affected when I did that? So you use single quotes when you are quoting something inside a regular quote, or you are quoting something that already quoted something. So it shows that you have a quote within a quote. Okay, in legal writing, when you got a really long quote, which is 50 words or more, you put them in a block quote, which is like something that's indented, single spaced in the middle of your document. You don't surround it with quotation marks. Okay, by putting it in a block quote, you have shown that it's a quote already.
Okay. How much detail concerning facts and judicial reasoning will a legally trained reader expect to see when I discuss cases?
So this one, I would say, has a pretty big division between law school and then out there in law practice. So you all, for people who are first years in law school, a lot of what you're learning is how to really show your work, right? How to show that you know how to read cases, you can analyze cases, and you can really explain them and identify what's important. And right, what's important in a case that you're going to use in a memo is the holding, the rule, and then whatever critical facts were the basis for the court's holding. So when you are writing law school memos, you want to show that work. Like you are really going to explain cases in full so that your reader, who is your legal writing professor at that point, can absorb the fact that you really understand legal analysis. When you're out there in the real world, we shorthand that a little bit more and often use parentheticals, which are short ways to describe a holding and the critical facts of a case, to explain cases. Sometimes when a case is super important to our issue, like the most important case, very similar to the facts of our case, a case decided by the highest court around, a case that's mandatory authority, we may describe it in more detail. So it's going to vary depending on the setting that you're in and the purpose that you're writing for and how important that case is when you are writing in practice.
Can you cover pronouns, and specifically, is it Paul and I or Paul and me?
I love that one too. So the answer is it could be either, depending on where it goes in the sentence, right? So Sin and I are doing a question and answer session on the Belonging Project's webinar this afternoon. And that's because both you and I are the subject of the sentence. But if you are the object of the sentence, I gave my favorite legal writing book to Sin and Laura, or to Sin and you, or Laura gave my favorite legal writing book to Sin and me this afternoon, then me is correct. So you're going to look at where it is in the sentence, and sometimes you'll use I if it's the subject, and sometimes you'll use me if it's the object. So I feel like more often people use, so for example, this comes up all the time. People say between you and I, it's almost always going to be between you and me.
Here is a common question. What is the rule on beginning a sentence with and or but?
So this one, in one of the workshops that I do at law schools, I have rules that have always been rules, and then I have like rules that are new or that have changed. So and or but, I definitely grew up hearing that you couldn't start a sentence with and or but. You also couldn't start a sentence with because. And I think a lot of us learned that. What I now know is it was because like second grade teachers thought if we started a sentence that way, we wouldn't write complete sentences. Okay, so they thought that it was just going to be like a clause after and or but or because. So the rule now is absolutely go for it. You can start sentences with all of those words, but especially is a really powerful way to start a sentence, probably way more powerful than however, because however is sort of, I don't know, a little wimpy maybe sometimes. So you can start sentences with any of them. You almost will never have a comma after them. That's a mistake I see frequently. So but and because, if you're going to set the reason out at the beginning and then complete your sentence, you can absolutely start sentences with all of those. There's going to be no pushback against that. I think that is a rule that now most people understand.
Wonderful. What connections will my reader expect me to draw between relevant legal authority and the facts of my case?
So I think that's another one where there may be some division between law school and law practice. In law school, they will want you to draw every single possible connection between the legal authority that you're discussing and the facts of your assignment. When you're writing for a judge, for example, you're going to have a page limit or a word count limit, so you don't have endless space to compare and contrast cases with the facts of your case. You're going to do what's critical, right? You're going to align the facts of your case with cases that are on point that you want the court or the partner to buy as governing of your issue, but you're not going to go into quite as much depth. You need to make it clear how a law applies to the facts of your case. Sometimes that requires more specific rule application, and sometimes it requires less. So it will be a problem of, it'll be a decision in context It's definitely more of an art rather than a science, but I would urge you, if you're a law student, to again, show your work, do more rather than doing less there.
And this will be my last question, but is there a preferred method to address comma splices? For example, conjunctions, separate sentences, or semicolons?
So for those of you who don't know, a comma splice is used to describe when you have two complete sentences. That means independent clauses, like I went to the store, then I went to the dry cleaners. Not that I'm going to any dry cleaners because I don't wear clothes like that anymore. And you connected those two sentences with a comma. Okay, you can't do that. You also can't connect those two sentences with no punctuation. So you got a few choices there. You can put a period between them and then you have a capital. Then I went to the dry cleaners. You can put a semicolon if you feel like, oh man, these two concepts, these two sentences are so closely related that they're a little closer connected than a period. So I'm going to separate them with a semicolon. And then in some cases, not in my example, you can connect two independent with a colon. And that would be if the second sentence explains or elaborates on the first one. So, and then I'm sorry, a fourth alternative is you could connect the two sentences with an and. In my example, first I went to the supermarket and then I went to the dry cleaners, and might be your best option there. So you want to look at those two sentences and how they are related. And based on that, that's how you make a decision about how you connect them together. But never with a comma and never with no punctuation.
Yeah. All right, we have some questions from the audience now. I'll start with one that's related to a question that you were answering prior. Where would one find a current version of the Blue Books these days?
Oh my gosh, that's a great question. So maybe you're lucky enough to, if you work at an employer or you are at a law school, I would email your library and ask them if they subscribe to the online Blue Book program. That is like far and away your absolute best way to get access to the current version of the Blue Book. A lot of big law firms, courts, places like that, and law schools do that because it's way more economical than like buying the little book for everybody. For super simple questions, like I find some answers on Google. Law schools around the country like post things about the Blue Book and about new rules. You know, I wouldn't go to the bank with it, but for some basic questions, you probably can use that. So if you can't get access any of those ways, law school libraries definitely have them. Law firm libraries definitely have them. I'm not sure what the current price is, but you could probably order it online, and I would bet it's about a $20 investment, not more than that. The Blue Book has at the beginning of it what they call the blue pages, which is like shortcuts for everything. That's my favorite part. I spend way more time there than I do in like the depths of all of those millions of rules.
Thank you. Now to one of my favorite questions we've ever gotten. What is the best way to approach getting feedback to continue to develop your legal writing when the assigning attorney is busy? How to avoid the general "your work is great" feedback and instead get feedback to help you develop as a legal writer?
That's one of my favorite questions as well. So it's a fine balance, right? You don't want to be like that annoying person who's, and I got to tell you, I'm sort of that annoying person who's always like, tell me how I'm doing, tell me how I'm doing. So you're being really wise to think about, how do I do this? You know, and you don't want to just take, you did great, you did great. You are absolutely entitled to more specific feedback than that. So my best advice here, you're never seeking out feedback in the moment, right? When people are in the middle of working on a deal or filing a brief. So you put no pressure on the people you're writing for that type of immediate feedback. Instead, you wait. My vibe is like you wait a week, okay? You wait 4 days, you wait a week. you email the person if that's how you connect with them, which is how most of us connect, and say, do you have 10 minutes to give me some specific feedback on, this assignment that I wrote from you? And then, because lawyers are so bad, like famously bad at sharing feedback, you try to make it easy for that person. So in our summer associate evaluations, last summer, we tried to make it easy for everybody. So we said, tell me 3 things that this summer on this assignment, or tell me 3 things that this summer associate could have improved, 3 opportunities for growth. So when I try that, when you ask someone, say, hey, can you let me know a few specific things that I did well here, and then a few specific things that I could have improved on, that makes it way easier and way less overwhelming for the person giving the feedback to actually provide you with some useful information. And people have asked me in the past, well, why do you need positive feedback? And, isn't that just to make somebody feel better? And the answer is not at all. You need positive, specific feedback because you need to know what you should continue doing in your next assignments. I need to know if my writing is really clear and precise so that I can look at that memo or brief and be like, hey, yeah, my sentences were shorter. I used really good, short, concrete subjects here. Look at my verbs, they're really good. My paragraphs are shorter. This was effective, so I'm going to try to do it again. And obviously, when you get opportunities for growth, the best thing you can do is seek out more chances to write for that partner, that supervisor, or others. The absolutely only way to get better at this is to keep on doing it. So one book that I really like was written by 2 lecturers at, I want to say the Harvard Negotiation Project, and it's called Thanks for the Feedback. And it helped me a ton understand how to receive feedback and how to absorb it and how to grow with it. And I got to tell you also, based on my experience at Schiff for 12 years, we care a ton about how you respond to feedback than we even care about the quality of the work. You show your maturity, your poise, your professionalism, your openness to learning by how you receive feedback. So remember that, and it's really, sometimes it's hard. I have to correct my facial expression, right? When somebody says something really negative, you want to not freeze up, not let your jaw drop, not, make some meaner face. But know that those moments are really important to your professional development and growth at whatever employer you're working at.
Great, thank you, Julie. When drafting a document on an area of law you're not familiar with, how do you find the law of the land or the common law on it?
So it's really, really hard to do that, especially in an area you're not familiar with. And for those of you who are starting out or working in more general practice firms, that comes up all the time, which, I know you've probably experienced. So, my best friend in this one is Google or Wikipedia again, because I read lots of environmental work. And I got to tell you, I can't remember what, CERCLA, RCRA, the Clean Air Act, the Clean Water Act, NEPA, and then you have state statutes, right, that say all these things as well. So I look them up to get some lay of the land, some context on Wikipedia, or just start looking and see what's being written about this topic. So I always start there. I would next start, and you can get these, of course, on Westlaw and Lexis. I try to look at secondary sources. So then I'd look at legal encyclopedias, or some of the other secondary sources that could really explain to me the concepts that I'm looking at. I would look at table of contents in treatises, for example. So let's say I was looking up some Civ Pro question that I didn't know. I want to see what all those rules are and what are the rules around the rule that I'm looking at. What are the subtitles in the table of contents? So that's a really good way. You want to get that lay of the land and not start out by diving into case law. That's one of these complaints I hear all the time from legal writing professors and from partners at law firms, which is that young lawyers like just jump right into the cases and look for the specific words and they don't understand the context. So start big, start broad, start by getting the language and an understanding of the field. And I know there's only so far you can get, right? It takes years, right, to be an effective patent litigator, for example. You're not going to understand all those laws at the outset, but it's worth it to really just spend some time. It might even feel aimless, and that's okay. Just browsing to get your sense of the field of law before you get more specific.
Coming. What is the #1 mistake you believe people make when starting a new writing assignment? Sorry to catch you mid-drink.
No, that was a great one. The #1 mistake there, well, I'm going to say two mistakes because both of these are huge. The #1 mistake is not really understanding the assignment before you get started in doing it. This is, in our summer program, the #1 complaint that we'll hear from partners every single summer, which is that, wow, this summer associate seems really smart. She's super poised. I really like her a ton. She wrote this beautiful memo for me, but it didn't answer the question that I asked her. So key to writing, to doing a good job on any assignment is get on the same page as the person you are writing for. Couple ways to do that. Someone gives you an assignment, you're talking on the phone or whatever. Before you hang up, you say, let me make sure I have this straight. You ask me to figure out whether a plaintiff can bring a CERCLA claim against a power plant where they were injured in this way. Okay, if you're not in a personal conversation like that, you can always do that by email. You can say, I'm getting started, thanks for the assignment. I look forward to working with you. I'm getting started, and as I understand it, this is the issue that I'm looking at. If you get on the same page as the person you're working for, you are going to be golden. Moving forward, it gives them a ton of confidence in you. It gives you a clear direction. So that is thing #1. Thing #2, the other way you can get messed up when starting a new assignment is not thinking and organizing what it is you're going to say before you start writing. Okay, and I don't mean every outline has to look beautiful and you got to make sure you use the A's in the right place and the little ones and the big ones and all of that. But even if you use the back of an envelope, you have to have an organizational structure for everything you write as a lawyer. Okay, memos, briefs, letters to clients, contracts, wills, everything needs to have a structure. You can't start writing without that structure. You can, but I gotta tell you, when I write something that isn't really organized, editing it is the hardest thing I've ever done. I can edit for words, I can edit for punctuation, I can edit for tone. It's really hard once you've dove into something and started writing something and you're like, oh man, I think my third point is really a subset of my first point. I really think this is not even a point that I made here. This whole paragraph, I don't know how it fits. That's really hard to do. So usually most things you do, it can be I have 3 points here. There are 2 parts to this answer, right? Part 1, part 2. Make it simple. And make sure you get organized at the outset when you get started.
Thank you. How do you synthesize a series of cases in a broader rule that's beneficial to a client?
So that's a really hard one. So as lawyers, it's so funny, in civil law countries where all of the law comes from statutes, it's what all American law students dream of, right? Where you would just look at the statute and you'd be like, here's the rule. I don't need to look at cases or regulations or figure out how everything fits together. But unfortunately, because we do have statutes and regulations, but we also have common law, we got to look at a bunch of cases often and figure out how they fit together like some sort of puzzle, right? Each case is a puzzle piece in that puzzle, but like the trick there is they don't fit together perfectly, like the, actually amazing puzzles that, puzzle makers make. So sometimes you're forcing something, sometimes there's a missing piece. So what you really do that can be very effective is some of our associates keep like charts where they'll be like, okay, this was the holding, here's the rule, here were the critical facts. Here's the holding, here's the rule, here are the critical facts. And you look at those together and try to see what sense you can make of that rule. Okay, and then I love what you said. You want the rule, there is some of this that's within your power to figure out how you describe the rule, whether you make it broader so that it covers your client's argument, or if you go narrower, and it might be the converse in other circumstances, so that you can say this rule doesn't apply to my client. So there you are thinking strategically, there you are answering a question in a way that you can advocate for your client. So you can't, this, you can't make these things up. You can't make up rules that don't exist. You can't say that rules are something that the cases don't support, but you can work to formulating a rule that helps your client.
What do you do when you're asked to work on an urgent assignment on an area of law you're not familiar with, and thus it's hard to know what questions to ask? Do you email? Do you jump on a call? Go to the office to seek advice?
You mean after you like scream in your, bathroom and think like, I can't do this, I'm going to get fired tomorrow? I always do that first, but I try to do that, not in earshot or eye shot of anyone, right? So, yeah, I would say what you do is going to depend on the person you're working with, how well you know that person, what the practice is at your offices. I would hope you're not being asked to come in if that's something you're uncomfortable with these days. Obviously, in typical times, sometimes we all did have to go to the office. So what I would try to do is you try to ask. So one thing, when you're going to have this call, somebody emails you and says, oh my gosh, I have an urgent assignment. Of course, it's Friday afternoon at 3. I need this by 6 o'clock. And you're like, oh, shoot, I had a Zoom happy hour scheduled. But of course, you don't tell the partner that either. So you have next to you a notepad that has some questions that you would ask for any assignment, okay? And so that's, who's the client? What's the billing? What's the context? Is this a case, a lawsuit that's been filed? Where was it filed? You have some basic questions. Who are the parties? What's the procedural posture? What are we working on right now? Who else is working on this case? Is there a file, electronic or otherwise, that I can go look at? So you can develop, and this is a great thing to do for young lawyers or people who will be summer associates, have your go-to list of questions, okay? You're gonna pull it out all the time. And then while you're in this call, and this is hard because I know you're like nervous, and again, you're missing your afternoon, so there's lots going through your head. You really wanna listen to what the person says and ask follow-up questions. You can never ask too many questions. In a context like this, I often find people are like, well, they expect me to know it. And the answer is no. They don't, at least not for a few years, and not if it's a new context. So for example, we have all these trust and estates lawyers. I have no idea what they do. I really don't understand it. A question I would ask is there a treatise that you all rely on to get answers to some of your questions? Is there a periodical? Is there something practical that everybody in the practice group or many of you use, to get answers? What's the most basic source that I can get, that I can read to get my head around this subject? Is there another associate, a young associate, someone else at the firm, a paralegal, who I might talk to with any questions? So that is what you do. You want to keep a clear head, have that list of questions, and then really try to listen during the meeting so that you can ask whatever follow-up questions you have. And then I wouldn't be hesitant to ask questions after that meeting. The only thing you want to be careful about, so I always joke, I used to teach legal writing at Chicago Kent, and I had one student over the years who would send me like 17 emails on a Sunday. And, you know, most of them were things that that student could answer on their own if they like slowed down and thought for a few minutes. But even if they couldn't, it's way better practice to gather up your, not your 17, but your 5 questions and either send them in an email and say, I have a few questions, here they are. Please let me know if if you think it's better to discuss them rather than sending question after question after question.
How do you know when your document or memo is truly ready and to turn over to the partner?
I love that question. So for me, the answer to that question is when it is actually due, because I have the hardest time letting go of anything before I have to let go of it. But that's not a good personal trait, so I'm not urging you to cultivate it. At the same time, you don't get a lot of points for turning things in if you took a little more time. So for example, if something's due on Friday morning and you think it would benefit from a final proofread Friday morning after you get a pretty decent night's sleep on Thursday night, by all means, wait. Proofread it in the morning, send it along, okay? If something is due at the end of the day, though, for example, and this is something you actually want to get on the same page as the person you're writing for as, end of the day is never gonna mean 11:59 p.m., right? And very few documents actually get better between the hours, I would say, of 8 and 11:59. So end of day is gonna be, I'd really like you to get it to me by 4 or 5. So you wanna think about that. You do wanna make sure, and you guys, if you're not sick of me by now, you can listen to the revising, editing, and proofreading webinar. You gotta make sure you have time to go through that revision process. And sometimes it's going to be a shorter one because you're rushed than it will at other times, but you're never letting anything go without making sure that it's going to meet your reader's needs, it's what they're expecting, it's clearly and precisely and concisely written, and it's correct. Because I gotta tell you, I read something, I read a writing sample that a law student submitted to our law firm, and there was a typo in the first sentence. And I'm thinking no one should ever be so rushed that you send anything out that has a typo in your first sentence. Just imagine how your reader is going to think about it without even, getting into your analysis. So proofreading is a step you can't ever skip.
All right, I think this will be our last question then. What's the best way to improve your writing?
So there are a few different things you can do. The number one best way to improve your writing is not run in the other direction when people give you a new writing assignment, but instead be open and accept them and even seek them out. All lawyers are works in progress when it comes to their writing. I work with people frequently who are, 20, 25 years out of law school, and one partner I'm thinking about specifically, and he'll write like 10 drafts of an introduction to an important brief before he's pleased with it. So the only way to get better at this is practice. It's pretty much like any other skill out there, right? And I don't know if it takes 10,000 hours, hopefully not, but it takes a lot of hours to get good at it. And then because I am at my home, you can look at my personal library and see a few things that you can also read. Hopefully you can see these to improve your writing. So they have in common the word plain English in both of the titles. If you look that up on Amazon and you just look up one of them is called Plain English for Lawyers by a guy named Richard Wydick, who was brilliant and one of the founders of the Plain English movement. Super simple, super short to read. And the other one is by Brian Garner, who some of you probably have heard of, who's like a big legal writing guru. And this one's a little dense. I don't know if you can't see it. The typeset is super small, hard to read sometimes. That one is called Legal Writing in Plain English, but it also has a lot of really good rules that you can use. So when you're like not up for serious thinking, but you want to learn something, those are useful. And then this one I'm recommending now on just general business writing. So like, you know, we all write a ton of emails, you'll write letters to clients, you'll write letters to opposing counsel. This is the HBR Guide to Better Business Writing. And this one is also by Brian Garner, but super short and easier to read than legal writing in plain English. So that's what I would recommend. Oh, and then one other thing, another way to get better at legal writing is read good legal writing. So go to the SCOTUS blog and find some cases that you're interested in, right? That'll be different for all of us, depending on your areas of interest, but there are always some hot hits that the Supreme Court is considering, and read some of those briefs that people are submitting. Those are going to be among the best advocates in the country and will give you some really good opportunity to learn how to improve your own legal writing.
Okay.
Thank you all for being such a great audience.
Thank you so much, Julie. We really appreciate having you back, and I always learn a lot myself. And thank you guys and everyone for attending this Friday afternoon.
And take care. If you have friends who couldn't make it today, feel free to let them know that the session's been recorded and will be available for them.